Do you want to know the one estate planning step that almost everybody misses? Hi, Nancy Beauvair here, certified executor advisor and the founder of NEXsteps. Well, stay tuned. I'm about to tell you exactly what that is. But first, I just wanted to let you know that recently CTV did an article about estate planning. And we all know that the estate planning process involves specific steps. And I've spoken many times about what those steps are. These steps are slightly different than the norm, though. The obvious first step is writing a will. Everybody knows that they should have a will, but yet less than half of Canadians actually have one. And of those people who do have a will, many of those are out of date. They haven't been reviewed. Things have changed, so they're probably no longer valid. When you create your will, if you do have minor children, it will outline who you trust to be the guardian for your children should something happen to you and your spouse and your children are left without their parents. It also is going to talk about the distribution of the residue of your estate. What happens to your assets? Where do they go? And that leads me to the second part of the plan, and this is the one that most people miss, and that is naming beneficiaries. Now, many of you probably do know, but there are likely others who are not aware that if you have assets that you're able to name beneficiaries on, those pass outside of the will. And there's a couple of reasons why that is useful. Now, here in my home province of Alberta, the court administration fees for the grant of probate are capped at $525 at the time of this video. And that's regardless of the size of the estate. But in other jurisdictions, such as British Columbia, Nova Scotia, Ontario, those fees can become very, very high based on the assets that are within your will. If you have life insurance, if you have RRSPs that you can name a beneficiary spouse, if you have a TFSA that you can name a successor, if you have any other kinds of assets that you are able to name a beneficiary on, those all pass outside of your will, and therefore they're not involved and incorporated in the residue of your estate for the purposes of the grant of probate. Not only that, but many people don't know that a will is a public document. Anybody can go down and ask for a copy of your will. They will see what your assets are, and they will see who your beneficiaries are. And if you're a private person or if you have assets that you don't want known, the best way to deal with those is to name beneficiaries on those assets. And that's the step that most people miss. They either don't name beneficiaries because they don't know that they can or should, or they don't update those. And that's a critical part of the puzzle here too. If you are a young person and you get married and you have your family, but then in 15 or 20 years, you end up with a divorce, but you never change that beneficiary and your ex-spouse is still named, that ex-spouse is going to get the benefits of whatever that asset was that they were named beneficiary on. So check those, update them. You should always be updating everything every 2 to 3 years, or, of course, whenever anything significant happens in your life. Another key component of your estate plan that a lot of people overlook is signing those powers of attorney documents. We think about estate planning as far as what happens when we die, but none of us thinks about what happens if we become incapacitated. If you're in a serious accident or suffered a stroke or ended up with an illness that reduced or impaired your cognition, who would make those decisions for you? A lot of people just make the assumption that their spouse will be able to step in, but that's not necessarily true. There are some things that, of course, the spouse will be able to decide, But there are other things that may fall outside of that right. And without the legal authority on that power of attorney document, then your spouse or whoever you wish to be your attorney under the power of attorney would have to go to court. They would have to petition the court for the right to make those decisions on your behalf. And that takes time and it takes money. Meanwhile, if you're incapacitated, who's paying those bills? How do things get taken care of? Those are important things. And make sure that you understand the distinction, too, between a power of attorney and an enduring power of attorney. A power of attorney typically is for a finite period of time for a specific purpose, where an enduring power of attorney lasts even if you do become incapacitated. Another thing that people aren't prepared for is that final tax bill. We don't have an inheritance tax, but we do have deemed disposition. And if you have an RRSP and it's worth, let's just say, $2 million, and you're thinking that you're going to be leaving that to your beneficiaries, you're going to have to think again. Because under the deemed disposition, if you are not able to name a beneficiary for that RRSP that qualifies for the tax deferral, such as a spouse, it's going to be deemed that you sold the assets in that RRSP right before you die. And that amount is going to be added into your final tax bill. There are stories of people being hit with hundreds of thousands of dollars of tax bills, and they end up having to sell assets in order to pay the tax bill. So make sure that you're aware of that as well when you're doing your planning. Talk to a tax professional, talk to your financial planner, and find out the best way to structure these things so that you can minimize that final tax bill. The final thing that I'm going to talk about today that is missing from estate plans: communication. Have you talked to your family? Have you told them your wishes? Have you discussed what is going to happen with your assets? Find out who wants certain specific items of sentimental value. It doesn't have to be a big or difficult discussion. Just start having the conversation. Take some time over a weekend. Go for a family dinner and just have the discussion. Not to be alarmist, but to just set the stage and make sure that there is not a lack of communication after you do pass, because that is what causes the divisiveness in many cases after somebody passes away, is the lack of communication, the hurt feelings, the lack of understanding. If you need some help with your planning, I've got a tool over on my website. It's called the Will Blueprint. It's going to help you identify everything that you should be aware of and that your lawyer should be aware of when you're drafting your will. I've also got an article on this topic that goes into more depth. The links for both of those are over in the description box. Thanks very much for joining me this week. I look forward to sharing more with you next time. Bye for now.